Good afternoon, everyone. Today we're going to talk about euthanasia, which is also known as a good death. I know there's a lot of question in relation to euthanasia and end of life practices in our mind. So we will try to throw some light on those questions and try to solve those questions. And so my group and I gonna discuss euthanasia and related ethics. So on board we have James Bond, sorry that's James, and Pei Shan, also known as Sandy, and myself Sandeep Gupta. Thanks. A quick overview on the definition of euthanasia. It's given by Palliative Care Association of Australia. It defines euthanasia as the act of intentionally, knowingly, and directly causing the death of a patient uh, at the request of the patient with intention of relieving intractable suffering. And in our current times, where our population is aging and our medical sciences have developed to a limitless arena, thanks to our medical sciences, a significant number of extremely sick people are maintained alive today. And due to development of these sciences, a large number of serious debates have come up to us. A high cost of treatment in terminal phases of life, a religious debate not to kill, right to respect and guarantee of autonomy. When we talk about euthanasia, the euthanasia term it's not by itself. Euthanasia can be divided into two classifications. First, based on the way it gets executed, and secondly, the decision-taking capacity of the subject. And based on the way it gets executed, it can be classified into two. It's active euthanasia and passive euthanasia. And based on the decision-taking capacity of subject, it can be classified into three. It's voluntary euthanasia, non-voluntary euthanasia, and involuntary euthanasia. Now let's talk about Australia and euthanasia. The first law legalizing euthanasia was passed by Northern Territory State Assembly, but it was voided by Commonwealth Government in 1997. A survey conducted in 2012 by Australian Institute revealed that almost 70% Australians favored the voluntary euthanasia for terminally ill patients. In 2007, poll results shown that almost 80% Australians favor euthanasia. Now following sets of table will show the parts of globe where either euthanasia or PAS is legal. Now I would like to share a real life example in relation to euthanasia, which is a case of Mrs. Diane Pretty, and she was from United Kingdom, where euthanasia and physician assisted suicide is still illegal. She was suffering from motor neuron disease, which is a progressive fatal condition that causes muscle wastage and ends to death. She was incapable of ending her life due to her illness. She wanted her husband to end her life, but he could have faced 14 years in jail for doing that. She went to High Court in UK, but she was unsuccessful in her plea. She appealed unsuccessfully to European Court of Human Rights in Strasbourg, and she died on 11th May 2002 of natural causes. The two articles from European Convention on Human Rights which are applicable to the case of Mrs. Diane Pretty are Article 3, which gives the individual the rights of freedom from torture, inhuman or degrading treatment, and Article 8, which gives the individual the rights of respect the privacy of family life without interference from public authorities. Now, I would be handing over the presentation to James, who would be talking about euthanasia and bioethical principles. Thank you.
James. I'm going to discuss the bioethical principles that arise whenever a decision on euthanasia is to be made. I will dwell on two models, the utilitarian model and the Kantian model. Whether you are looking at euthanasia from the patient's perspective or the physician's perspective, conflict seems to arise on the bioethical principles. The utilitarian model emphasizes on consequences. Utilitarianism is about maximizing benefit and reducing suffering. According to Tanjov, from a patient's point of view, euthanasia is assumed to be the option with the best outcome. Euthanasia to a patient with a degenerative disease reduces suffering and cuts down on expenses for medical interventions. It should be noted that a decision on euthanasia does not does not does not exclusively focus on the suffering patient, but also on the relatives of the patient and the society in general. Euthanasia may be wrong if it has a negative effect on the society and the relatives. Thus, utilitarianism only supports euthanasia if the society in general is in support of the patient's decision. A physician's decision on euthanasia in most cases is derived from the utilitarian approach. Physicians base their decision on facts. Thus, the basic approach for a physician would be the greatest happiness for the greatest number. Frequently, a cost-benefit analysis is done so as to arrive on a decision on the maximizing of efficiency on the outcome of a certain decision. Brooks, in her article, she argues that other people's needs and wishes cannot be used as a yardstick in assessing an individual patient's dignity. So, in, in whichever case you're looking at euthanasia, a case-by-case study should be done in order to legalize or allow the euthanasia to go on. Miss Pretty went to court seeking her right to die at the time of her own choosing. Miss Pretty thought when problems of MND like breathing difficulty, progressive paralysis advanced in later stages, her life will not be worth living. This would be justified in a utilitarian approach. In a different interview, we also learned that although her husband and son understood what she was going through, they wanted to spend more time with her and were not in support of the euthanasia as she was requesting. I'm going to move to the second model, that is the Kantian model. This model emphasizes on the respect for autonomy. Sikora in his article argues that each individual owns in a moral sense himself or herself, and we are free to do what we want with ourselves. Autonomy has been the best justification for legalization of euthanasia, but in the matter of ending one's life, it has to be looked on various moral grounds. From a liberal perspective, Miss Pretty has the right to make a decision when or how she should die based on the principle of autonomy. Miss Pretty might have been mentally sound when she made the request for euthanasia, but her request might not have been autonomous, as her terminal illness could have eluded her capacity to make the informed choice. Furthermore, Miss Pretty's autonomy is not absolute, and the notion of self-determination entails that her right to lead her own life is conditioned by the good of the community. In this case, the good of the community could be at risk of harm if euthanasia is granted. Goldman also argues in his article that everyone has the right to life, and the act of euthanasia is against it, according to the Universal Declaration of Human Rights. We learned that legislation on euthanasia may have a negative impact on the society, in that it may create pressure for others in certain situations to request for early deaths.
3.
I'm going to discuss the principle of non-maleficence in relation to the case of Miss Pretty. In the principle of non-maleficence, we learned that physicians should do no harm to their patients. Miss Pretty argued that palliative care as a means of managing her terminal illness will not cure or provide a lasting solution to her suffering. In trying to keep Miss Pretty alive, this could inflict more harm than good, thus euthanasia could be the best option. In the harm principle, as an integral part of the Hippocratic Oath, prohibits the physician from helping patients end their life. Thus, participating in euthanasia is viewed as contradiction to the non-maleficence principle. Next is Sandy, and she will be talking about slippery slope argument.
Hi everyone, I'm Sandy. Next, I'm gonna discuss euthanasia and the slippery slope argument. Two common arguments against permitting active voluntary euthanasia, even in the most disparate of cases. The slippery slope argument and the argument that further research into terminal care and pain control will be discouraged. The decision to not allow Mrs. Diane Pretty to perform euthanasia was largely based upon what is popularly called slippery slope. The decision of UK court was based upon the fear that if Mrs. Diane Pretty and other similarly competent adults were allowed to opt for physician-assisted suicide, then the practice might become harmfully extended to vulnerable adults lacking full capacity or to those whose choice have been influenced. Those who favor physician-assisted suicide or voluntary euthanasia do not deny that they are slippery slope dangerous, associated with legalizing physician-assisted suicide or voluntary euthanasia. But at the same time, they argue that more rigorous legal safeguards can provide substantial protection against possible abuse. But contradictory to the fear that slippery slope argument might lead to exploitation of vulnerable individuals. There is no evidence available in the jurisdiction where physician-assisted suicide or euthanasia is legal to support this argument.
Arthur Schaffer, in his article, mentioned that there are safeguards in place to ensure decisions on euthanasia are substantial, and hence it's appropriate that a person seeking to hasten their death should be granted. Various safeguards in Netherlands like voluntary written consent, mandatory reporting, second opinion, and consultation have proved useful in managing euthanasia. Hence, evidence shows that euthanasia should be permitted, and there is no evidence present in the literature that permitting euthanasia or legalizing euthanasia have led to some kind of harm to society.
It might seem